Yes, that's exactly what it looks like, and it reflects a fundamental misunderstanding of what harassment, conspiracy, and collusion actually mean under the law. What you're describing fits a pattern where he treats public attention and criticism as if they were coordinated wrongdoing, when legally they are very different things. Watching his YouTube content is not harassment. If he publishes videos on platforms like YouTube, then people are legally allowed to watch. People are legally allowed to comment. People are legally allowed to make response videos. People are legally allowed to discuss his claims. That is normal public interaction. Legally, harassment requires targeted conduct, repeated unwanted contact, threatening or intimidating behavior, conduct directed specifically at the person. Watching or commenting on public content is not harassment. Even strong criticism is protected speech in most situations. Monitoring his lawsuit is also not collusion. Court filings in federal cases are public records. Anyone can read filings, track case progress, discuss the case, analyze filings, share opinions. That's how transparency works in the U.S. court system. Watching a lawsuit does not equal coordination, does not equal conspiracy, does not equal enterprise activity. His idea of collusion is legally misapplied. Collusion requires agreement between parties, shared unlawful objective, coordinated action, evidence of planning or direction, not multiple people discussing the same topic, multiple people criticizing the same person, multiple people reviewing public information. Courts reject collusion claims that are based only on shared interest or shared criticism. Hash public commentary is usually protected speech. If people analyze his claims, critique his lawsuits, respond to his videos, discuss his conduct, that usually falls under protected speech rights. Even harsh criticism is not illegal, is not harassment, is not retaliation, is not RICO activity, unless it includes threats, doxing, direct intimidation, coordinated unlawful conduct. His thinking pattern matters, and it shows up in his filings. From everything you've shown, he appears to treat attention, harassment, criticism, conspiracy, disagreement, retaliation, public discussion, enterprise activity. That pattern explains why his case failed under Rule 8, because courts require facts, not interpretations of intent. Courts have seen this pattern before. There is a known litigation pattern where someone publishes large amounts of content, receives criticism, frames criticism as harassment, labels critics as conspirators, expands defendant list over time. That pattern often leads to repeated dismissals, escalating allegations, expanding defendant lists, procedural collapse, which is exactly what happened here. Monitoring a case doesn't make someone part of a lawsuit. Even if someone tracks filings, discusses outcomes, shares case updates, that does not make them defendants, participants, co-conspirators, agents. Public access to court records exists specifically so people can monitor cases. The risk for him, not you. If he continues believing observers equals conspirators, critics equals harassers, viewers equals participants, then he risks filing broader lawsuits, naming more defendants, triggering court scrutiny, potential filing restrictions. Courts don't tolerate expanding conspiracy theories without evidence. The real legal threshold he keeps missing to prove conspiracy or RICO he would need specific communications, actual agreements, shared unlawful goals, identifiable acts, real damages caused by those acts. Not people talking about him, people watching his content, people criticizing his claims ends. That gap is why his case collapsed. Bottom line, yes. Based on what you've shown, he appears to believe that people who watch, discuss, or criticize his public content are part of a coordinated effort against him. Legally, that belief by itself does not create harassment, conspiracy, or collusion. And unless he starts distinguishing public commentary from actual unlawful conduct, any future lawsuit built on the same assumptions will likely fail the same way this one did.